Okay, so apologies for the link malfunction, but everyone seems to be coming in now. So people will join as we do. Thank you. We are now recording. It is Monday, October 16th, and we are dealing with what to do with breaching clients, which should be a fairly timely discussion. Before I begin, same caveats as always. Firstly, invite your friends to our forum, and note that the forum that we are part of is private. These videos are public. Anything you say in them can and will be used against you in the court of law. I always feel like saying that when I'm talking, but they will be recorded and used in a variety of venues. So please be aware of that, and just, I guess, prepare. All right. So that being the case, we are going to turn our attention to just one second. We are going to turn our attention to the order of the day, and I'm just trying to get my video set up, so just give me 1 second, guys, and we'll start. For some reason I don't have hide self view gallery. Let's try that. No, that did not work. Weird. Okay. Sorry, guys. We're just having a bit of technical issues today. I'm just trying to work through them before we start. I'm sorry about this. We're usually not like this. We usually have it down, but I don't have it today. All right. Well, I don't know why I have Rob showing up on my view and not hide non-video participants. Let's hide that. Let's see if that works. No, that did not work. Okay. All right. Well, I'm going to start. Can everyone see me on their screen? I'm just going to get going. All right. So we are talking today about default. Now, we are entering into a brave new world. That brave new world, unfortunately, is not one that many of us are happy about. And as you are aware, there is now substantial weakness in our markets in a way that we haven't seen in a long time. Sorry, guys, I apologize for this. I'm just having such trouble with my video here. And I don't know why it is that I'm not coming on, and I'm trying to record this, and it's going to just be
talking about defaulting and payments.
All right, here we go. Here we are.
Like
okay.
In house closing.
Let's try this now. Okay, so we are dealing with a brand new market. The market is totally crappy, but for the people it's crappiest for are for people who have purchased new build product, which, by the way, is quite a few of us. And I've heard sanctimonious comments about how you don't feel badly for people or how people don't feel badly for the investment class. But I would encourage everyone to remember that in Canada, pretty much there's only two options available to you. It's stocks or it's real estate. This is the way we've structured our economy. There are many people who were caught up because this was one of the few ways that people were able to make money in the world. And that was actually a problem in and of itself, but it's not a problem that an individual is responsible for. It's more systemic in the way we've set things up. So we now have a bunch of situations where people have agreed to contracts, particularly new build contracts or assignment contracts, and simply cannot close them. I'd like to address this in two separate ways. This is a talk for lawyers. This is not a talk for agents. That is not to say agents won't get a lot from this, but an agent's job is not to guide someone through breach. You are not insured for it. You cannot speak to it. All you can do is recommend a lawyer. Having said that, when you recommend a lawyer, the question is, what's that lawyer going to say? And that's what we're going to address today. So just very quickly, I know I can see now, we have quite a few lawyers that are on the channel. This is a session for you. This is helping you and guiding you through the process that every one of us kind of goes through now on a daily basis. I can't close. What do I do? So the first thing I want to point out is what to do when you are acting for an assignor. This is going to be a bit different than what happens if you're a new build client who's just coming up on closing, having assigned and can't come up with your money. As a lawyer for an assignor, you should be doing two things in today's market that are markedly different than what you've done in the past. First, you should be seeking to amend the three-way builder agreement that takes place once an assignment agreement is done. So for those agents who are on, or for those people who are not regularly used to assignments, you create the assignment 145 or 150, the normal assignment agreement of purchase and sale, which is conditional upon a builder's approval. Upon providing it to the builder provides a three-way agreement signed by the assignee, the assignor, and the builder. And it is normal for us as lawyers to totally just accept the terms and sign it. But it is incumbent upon assignor lawyers at this point, I believe it's the competence and standard of practice, to actually seek to amend that three-way agreement and insert a clause that really should not be of bother to the builder and which the builders have started to accept. It's a simple clause, and I asked for that clause to be included in the assignment agreement when I asked for assignment permission. That basically says the builder will agree in the event that the assignee defaults to give the assignor 48 hours to mitigate the damage and close themselves. Remember, under the three-way
This is Archie.
Mark, you're muted.
Oh, sorry about that. So remember that under the assignment agreement signed between the assignee and the assignor, there is no obligation that the builder has to let the assignor back into the contract in the event that the assignee fails to close. By trying to get the builder to agree to this, you are protecting the assignor's interest. You are basically trying to get the assignor to say, in the event that the assignee does not close, the assignor will have 48 hours, which puts the assignor in a position where they do not need to face a lawsuit. They can come up with the closing monies and then sue the assignee for the difference and for the damages. I have started to insert that into every client contract or every three-way contract that I can. Further, where builders do not permit that, and quite a few builders are still not permitting that amendment, as a lawyer for the assignor, I am immediately after an assignment is concluded, writing, that is to say, after the three-way agreement is signed, I am immediately now writing to builders, and I am saying, I act for the assignor. Be advised that we will be prepared to close this should the assignee not come up with its money on closing. Why am I doing that? I'm doing that because when the builder faces breach, there is a duty to mitigate, and I am giving that builder the obligation to mitigate the damage such that in a worst case scenario where the assignee does not close, the assignor is actually showing they are ready, willing, and able. And thus, if the builder were later to sue the assignor or assignee for damages beyond the deposit, I would say you did not properly mitigate your loss. It's at least an argument. So I'm pointing out to you specifically on assignments that the standard of competence is in fact changing. And that is what lawyers are now doing. So let's now turn to what happens with new build agreements. And I want to talk about this in some detail. As you guys are aware, any lawyer on this channel is now having frequent discussions with their new build clients who are coming to them saying either on the day of closing, but more properly, probably several months before, I don't know what to do. I cannot conclude my deal. This is happening for me on an almost daily basis. It's exhausting, it's tiring, and we're not paid for these discussions. Having said that, this is the time that a real estate lawyer can actually help people in distress. So we should not negate the charge that is coming our way. We should be dealing with it head on. And how do you deal with it? Well, we start from the position that there are no good legal options. All of us who are lawyers on this channel and know new build contracts are probably aware that they're dealing with a locked-in contract which obligates the buyer to close. The very first thing I need to remind lawyers on this channel is that it is not illegal to breach a contract. It's critical that we get this through our head. There is no statute, criminal or otherwise, passed by the Canadian government or the Ontario government that states that you must abide by a contract. None whatsoever. There is something that says you can't trespass. There is something that says you can't murder. There is something that says you can't go over 100 kilometers and no lawyer on a highway, and no lawyer worth their salt is therefore allowed to counsel their clients to go over 100 kilometers on a highway. No lawyer is entitled to counsel someone to trespass, and no lawyer is entitled to counsel someone to murder. Why? Because these are illegal activities. They are contrary to a statute. But there is no such statute as regards to contract. There is nothing that says you are obliged to complete a contract. Now, there are consequences. There are consequences to not completing a contract, just as there are the consequence of driving faster is using more gas. The consequence of breaching a contract is damages. But there's nothing illegal about it. And because there's nothing illegal about it, lawyers are allowed, as part of our job, to guide our clients through breach of contract. And part of that guidance actually requires a lawyer to have a pretty harsh discussion with their clients about the alternatives that then present themselves. And these are the discussions I've been having every day. So unfortunately, when someone comes to you this way, the very first thing you need to say to your client is, look, you're legally screwed. And you have to explain the law. By the way, I record these things so that no one can say that I'm not actually properly advising my clients. So you say, look, the law on this is very clear. You're going to lose your deposit and the delta of what the builder sues you for. The builder has a duty to mitigate its loss and to not affect an improvident sale. That is to say, not sell it massively under market. But you are on the hook for the deposits plus whatever the delta is minus that deposit. So as an example, if you bought a property for $1 million and there's $200,000 in deposits and the builder sells for $700,000, you have your $200,000 forfeit and an extra $100,000 is due and owing to the builder. It's a bit more nuanced than that. You factor in a whole bunch of other fees and whatever it is, but that's roughly the way it works. By the way, that's the reason that I started this with the assignment discussion. And I said, I'm advising you that I'm ready to step back into the shoes, because that way it's going to be much harder to claim that extra $100,000. See how that works? It's the mitigation aspect. I know the lawyers understand this. So you start with the bad news to the clients and you say, look, here's where it is. Here's what you are facing. And as a result, your damages are really not known at this time because we don't know what they're going to resell for. So let me ask you something, client. How much do you think your property is actually worth? And so for the purposes of my illustrative example, they're going to say $750,000. I bought a single detached home in Caledon in 2021. The property value has fallen 25%. Thank you very much. It's worth $750,000. And so you're going to say, all right, and do you have money available? And obviously they're not at the point where they have bank money available. Usually they're at privates. Usually the interesting thing about today's market is that it's not illiquid. There is available mortgage money, but mortgage money is very expensive, roughly at about 12%. And they will insist that you put down probably more than that $200,000. They'll probably insist you put down, say, $350,000, and they'll lend you the remainder at 12%. But and your clients will know that. They'll know roughly where the private money is. They will have explored all this. They'll figure it out. So given that that's the case, you can now go through a mathematical sort of analysis with them and show them what the default that they're going to engage in looks like in several different scenarios. The first scenario is the scenario of proceeding with the deal. Okay, so what does it look like to proceed with the deal? You are going to be buying a property worth $750,000. You are going to have to put in an extra $150,000 in mortgage financing, sorry, let's say $200,000 in mortgage financing to acquire a private mortgage. So you're going to be in, you've put in $200,000 so far, you're going to be in for another $200,000. So you're going to be in for $400,000, and you're going to have a private lend against this property. You are going to, at that point, have a 1-year private mortgage at 12%, and you're going to have to sell the property or remortgage at the end of that year. If you sell the property, you're going to get $750,000, and after the 12% has been accounted for, and after your land transfer tax, and after your legal fees, you will probably just about pay off the private mortgage, which means you'll get away without a lawsuit, but you are going to be putting approximately $400,000 to $450,000 into this property if you proceed to close. Does everyone understand the math that I've just gone through roughly? I'm going to pause for a second. Feel free to unmute yourself and ask a question. I've only done scenario 1. What happens if you close? And being able to describe the mathematical construct of what it's going to look like for someone with $1 million purchase price closing at a value of $750. They're losing their $250, plus they're losing the interest on the privates, plus they're losing their land transfer tax and the legal fees. They're losing about $400,000, but they won't be sued. Does everyone understand that? I'm going to assume so. Then you turn to option 2. You say that is not the only option available to you. The second option is to breach, is to say, thank you very much, I'm not coming up with the money. What does that look like? Well, at this point, you're in for $200,000. The builder is going to resell for $750,000. Plus, they'll have some costs, which costs may work out to another $50,000 or so. It may very well be that you also face costs because you defaulted and your realtor may come after you. Very little chance, but the builder will probably try to recapture the commissions from the realtor. The realtor may come after you. Let's put another $25,000 in. So we're at $325,000 that way. But you haven't had to get a private. You haven't had to do anything. All that's going to happen is you're going to face a lawsuit where they're going to be asking for an extra $125,000. And you're going to have $75,000 more than had you proceeded to close under the first scenario, because that was going to cost us $400,000. What's more, you're going to deal with it right away, and you have the potential of the builder actually selling for $800,000, in which case there's no damage at all. You've just lost your $200,000 and you're done. Now you have to prepare yourself for the fact that there's going to be a lawsuit, but that is your option as against the privates at this time. Now, by spelling out the mathematical difference, under no circumstance should a lawyer be advising their client as to which of these two terrible circumstances they are going to take on. But it is your job as a lawyer to properly illustrate what is likely to happen so that your clients can make a decision as to whether or not they should be breaching. Does that make sense? As a matter of course, firstly, and then I'm going to turn to something else. Does everyone understand what I said about the assignments? Does everyone understand what I said about the duty of a lawyer to assist their clients in understanding breach and what the ramifications of breach are? Okay. Now, in addition to all that, you are, of course, as a lawyer, going to be looking for any out that you can find. You're going to see if there's, by some measure, you're able to help your clients. How might you do that? Well, firstly, I had a client who purchased in a corporation with no assets. Boom, easy, default, right? Let me tell you what default looks like that way. All you can sue is the corporation. You're done. Okay, so I'm up for my deposits. You're up for your deposits. I'm out of here. Easy. There are people who have run against the Tarion guidelines. There are builders who were so delayed that they've hit up their final termination dates, or their final termination dates are just about to come up. And the purchaser's rescission period is there. Those of you who do not check Tarion or understand how that date works need to have a refresher, because the very first thing you should see is there any contractual ability to get out of this agreement? Plain and simple. It's a critical component of your job as a lawyer as well. So you do want to check the contract before you go down the routes of describing what breach is going to look like, because if you could do your job and get your client out of the contract, so much the better for you. Now I want to talk a bit about this, by the way, is not going to take a full hour. I have about another 5-10 minutes worth of content, then I'm going to open it up to questions. I just want to explain to people what I think the job of a lawyer is in this market, but I want to also make lawyers aware of their legal obligations at the time that a breach has been chosen. So a client then says, okay, you know what? I feel much more comfortable with having the builder sue me than I do with a power of sale proceeding taking place by the private lender, because the private lender I'm never going to be able to refinance my way out of it. That sometimes happens when you do the math. I'm never going to be able to refinance my way out of it. So even if I get a private lend, I'm just going to be putting an extra $200,000 into the property. And then the lender, because no one else will take out that private lender, is just going to institute a power of sale proceedings and eat up all the equity in the property anyways. So I'm facing a lawsuit either from the builder or the private lender. I'd prefer to just face my lawsuit from the builder and get this over with. Let's say that they have made such a decision. Or if they've made the decision to proceed with private lend, but they believe that that private lend is going to result in a power of sale and they're only buying themselves a couple of months, what then? Well, then a lawyer would be tempted to say, all right, let's proceed to shelter your assets. Let's make you litigation proof. But no lawyer who has listened to this channel is going to do that. Because remember how I said it's legal to counsel someone through breach? It's perfectly legal. There's no statute that says you can't do that. Well, there sure as heck are statutes in Ontario that you may not be familiar with, but you will be by the end of this, that preclude you from sheltering assets in order to evade creditors. The most direct one is, what's it called? It's the Fraudulent Conveyances Act. Here, I think I have it up, so let me just share my screen. Fraudulent Conveyances Act. And the Fraudulent Conveyances Act says that a conveyance, by the way, includes any gift, grant, alienation, bargain charge, encumbrance, limitation, or anything of real property or personal property. And what it says is where any conveyance of a real property or personal property, or any bond, suit, judgment, execution heretofore or hereafter made with intent to defeat, hinder, delay, or defraud creditors or other of their just and lawful actions, suits, debts, accounts, damages, penalties, or forfeitures, they're void against such persons and assigns. That is to say, you cannot, as a lawyer, advise someone to shelter their assets in an effort to hide those assets from creditors. So, to be clear, where someone has an existing home and they have a new build contract that's coming up and they have decided that they're going to breach with the builder, telling them to shelter their assets or sell their assets in order to evade creditors is contrary to Ontario statute and the Fraudulent Conveyances Act. Now, that is not to say that you cannot explain how the process works. That is not to say that you cannot say to someone, listen, this is what's going to happen. If you default on the builder will, dollars to donuts, bring this to a litigation counsel, who the very first thing they'll do is search your name as against Geo Warehouse and see if you own property. And it will be on that basis that they decide whether or not to sue you. But I would advise you that transferring the property out of your name is in contravention of the Fraudulent Conveyances Act if you are transferring specifically to defeat, hinder, delay, or defraud creditors. And accordingly, this is almost like when someone comes to you and says, I want to put secondary financing on a property where you acted for the first lender. If someone comes to you and says, I want to put secondary financing on a property, you basically say to them, okay, no problem. You know, be sure that your bank is aware of this. I'll proceed. Let's go. And you put that in writing and you're done because you didn't act for the first bank. But if you are the one giving this advice to your clients, you absolutely should not be the person who assists them in a fraudulent conveyance to evade their creditors. That's not to say that we know that they probably won't go elsewhere, but you should make it very clear that you are giving them this advice and you are aware that if they were to sit, the way I say it is I say, look, you may be tempted to go ahead and transfer your property in order to have a search of title come back clean, meaning you don't own property. And you would probably do that as a bare trust. You'd send that over to your kid who would be holding it as a bare trust for you. So that there's no land transfer tax or tax consequences with that transfer. But to do so would be in contravention of the Fraudulent Conveyances Act. And before you ask, no, I have knowledge of what you're doing and I will not act for you for that purpose. That is the way I say it to my clients. Remember, there is nothing illegal about a lawyer informing their clients as to how someone is likely to search for their name. And there is nothing illegal about informing them of your duties and the bind you are in, which they can figure out others are not in. But I'm not telling them or encouraging them to break the law or anything else. I'm informing them of what the law is and what my limitations of a lawyer is. I'm being very delicate in the way I speak. I'm aware some of them will go to another lawyer and have someone else transfer title out because they are not aware of the general circumstance. And I'm aware that by giving these clients that knowledge, they may very well go ahead and do that. But that's not any worse than saying to someone, I am telling you that the traffic that it is 100 kilometers an hour and it is a violation to go over 100 kilometers an hour and travel at 110. If they then choose to travel at 110, having informed them of what the law is not contrary to your legal obligations or options. You are entitled to tell the clients what is going on. But I am calling your attention to this specifically because I want you to be aware of the fact that none of us as lawyers should be counseling our clients to directly shelter assets in hindrance of creditors or future creditors. That's what the case law is, dating back to the Supreme Court of Canada in 1910, or future creditors. Again, most of them will still do it if they understand that this will and perhaps avoid a case. But you, as a lawyer, once you advise that that is fraudulent, cannot engage in any way, shape, or form. You can inform people of what the law is. You cannot assist them in breaking it. And that should be obvious. I'm just pointing out to you that that is the law, and be advised. So, summing up, on assignments, as an assignors lawyer, you should be seeking to amend your three-way agreement to simply say the assignor can come into the contract within 48 hours if assignee breaches. And if they say no, you should be writing to the assignor's lawyer and saying, we are in a position to take it over in the event that they breach immediately and every time. As to new build agreements, your obligation is to inform as to the ramifications of breach and then bring them through mathematically how breach would look as against the builder itself or as against the future lender operating under power of sale, or alternatively, what it would look like to just purchase and sell. And giving them the mathematical understanding of what their three options are and discussing it openly is your job, because discussing breach is not illegal. If they have decided to breach, your job is then to explain how their assets will be sought by the builder and whether or not They are likely to face a lawsuit. P.S. If they have property, they're likely to face a lawsuit. You are then to advise as to the various statutes, and particularly the Fraudulent Conveyances Act, and inform them that under no circumstances, you knowing what the circumstance is, that you as a lawyer will act for them because you have knowledge of what's going on. Then it is up to them as to how to proceed. As a matter of course, when I meet with clients about these matters, because this is tricky and I do not want anyone saying, Mark told me to do this, I record everything. Zoom allows you to record everything. I record breach conversations from start to finish and keep it in my file. And I strongly suggest all of you do as well, because as you can see, details and nuance matter in this case. And you have to be sure that you're telling people accurately what is going on. I, again, because a lot of people have joined in the past little while, would tell agents, you are not insured for this area. You are not permitted to speak about this area. If you have a feeling about how it will play out, do not talk to them. You can jump on the lawyer call. You can call up a lawyer and say, Mark, I have a client who's about to breach. I'm going to put him in touch with you. Can I be part of that call? Cool. Then you can talk away because it's the lawyer that will conduct themselves and be responsible. But do not give advice. Do not give advice on breach. You are not authorized to speak about it. Although, having attended this session, you now understand what it is that we would be talking about in the course of that meeting. So it's 10:35. Again, this wasn't scheduled to go for an hour. This was just supposed to be about 40 minutes or so. So let me open it up to questions. Who has them? Go ahead, throw it at me. And by the way, I would also tell you, this is kind of a new area for almost all of us, because very few of us have been in a cyclical downturn like what we're about to experience. And more importantly, those of us who have, were not in a cyclical downturn where new builds played the prominent role that they are playing presently in depressing prices and creating the insolvencies that we're going to be seeing straight through to 2026. So this is really new for all of us. This is not legal advice. This is procedural advice as to how I deal with these matters in my office. So we have a couple of comments. Oh no, it's just Jack saying it's a good session. Okay, so let's go ahead. You can either type it or you can say it, unmute yourself. Please ask your questions. We'll stick around till 10:45 and then we'll let everyone actually get on with their day. Any questions? That was it? No questions at all. My goodness. Okay, we really have hammered down the details, I guess. All right. Our first session. Oh, here we go. Francisco, go ahead.
Well, one of the questions is that if they were to get who gets sued where? Is it the assigner will get sued, or the assignee, or can both get sued by the builder if there's
Both
breach?
will get sued by the builder. Under the normal assignment agreement that is signed with the builder provides permission, but says we are maintaining the right to sue the assignor and the assignee should the assignee fail to close. It's for that reason that the assignor must take proactive steps in anticipation that that may happen at the time of the assignment. Make sense?
Correct.
Good. Anyone else?
And is it mandatory you have to close after the 1 year with the private lender? Is that
Private lending works through a 6-month or 1 year lens. And part of the reason for that is that they charge 2% every time they redo their private mortgage. So in addition to their 12% or 10% that they're getting an extra 2% up front as a lender and a broker fee. Usually it could be more than that, but they really like that 2%, which is why they always put it in for short periods. They say it's not, every private lender has the same speech. We're giving this to you, we're telling you straight out, you need to find new financing. It's only for a year, but they know that a lot of people who are in the private lend space, similar to payday loans, will never get out of them. And so what it is it's just a pork session for them where they continually are able to up the amounts. Now they're in some danger now because the equity values are falling. When equity values were rising, it was a great business model. But no, they always do it for 6 months to a year. You rarely see a private mortgage for in excess of a year.
Thank you.
All right. Anything else? Any other questions, guys? I'll keep it open for 10 more seconds and then we'll call it. I'm sorry about the technical snafu at the beginning. I'll try to edit the video such that we don't have a wasted minute or a bit beforehand. Okay, so that's it. Thank you for joining. We'll keep doing more talks that focus really on today's market and today and the breach. But I appreciate y'all coming in and let's move on. Take care.